Yes, good evening to everybody. Welcome to the today class of the Advanced Private International Law. I put it over there on the screen, the syllabus. There is a course outline, and where you could see the conceptual issues and basic doctrinal issues in private international law. It is nothing but the connecting factors. And in the absentia that we deal the private international law or the conflict of laws. And today class that I would like to deal the foreign law. And we have dealt in detail at least 3 clauses in the domicile, nationality, and residence, and a cause of action in its lex causa that we will do in further classes. Of course, the judicial issue is a small point of view, and the big point of view is the foreign judgment. These things that we are making it. Without wasting the time, let me come to the point of here. Could you read it, what I posted on the screen, please? Unmute and read.
Foreign law versus international law.
Go ahead.
Foreign law, the law of another state or country. International law, the legal principles governing the relationships between nations.
Yes, I said good evening. Then the foreign law versus international law. When you write the verses, please keep in the mind, we should be small letter and the full stop. And the party should be in italics. That is the fundamental rule. If it is parties, here the foreign law versus international, they have given it how it can be there. Then what is meant by the foreign law? Just it is nothing but the other law country, other state law, other country law is said to be the foreign law. Example, can you give me the example? Yes?
The United Republic of Tanzania.
That is our own country law.
The law of the state. The Constitution of the United Republic.
No. Why don't you say that Kenyan law, Ugandan law, Indian law, Botswana law, it is said to be the foreign law. But we are studying over there the private international law in the Tanzania, and it is a country law. There is the law of the land. So that is the law of another state or country. That is the meaning. Is it clear? Say yes.
Yes.
And then what is meant by international law? It is nothing but the principle governing the relationship of the nations or states. And there we can say the public international law, especially from the state to state. When you come to the matter of the private international law, as you know, the state and individual, or the individual and the another individual. But the two individuals from the different states. So that we will come across it. Now let us see that what is meant by the foreign law. Can you read it? Which I put it on screen. Yes, I magnified it also.
Foreign law. Foreign law, to a large extent, the subject matter of private international law is foreign law. Unlike comparative law, which compares foreign law, private international law investigates the extent to which foreign law may be applied in another legal system. The application of foreign law can arise in any context, although it is particularly relevant in the field of choice of law.
Very good. Very
there are
good.
A number of
enough. That much is enough. I will give the explanation here. See, what I exactly say, the subject matter of the private international law. See, private international law dispute comes at that instance only when there are two state subjects. Means one is from one country, another is from
country.
Another country. So another country is a foreign law, means foreign country. And that law is said to be the foreign law. So here comparative law, which compares the foreign law, private international law. So when you say the private international law, it deals with the person or the state, person to person, but cross boundary. Means two states should be involved over there. But foreign law is a country of another country, is a law of the another country. I beg your pardon. Is it clear? So the application
Yes,
is
Professor.
yes. Shall I proceed? Shall I proceed?
Proceed.
Essentially, the application of the foreign law can arise in any context, although it is particularly relevant in the field of choice of law. Now the question comes over there. When you want to say the choice of law, yes, the law of the Tanzania and the facts and the law is the same. And let us presume that the law of Kenya, the facts and the law is the same, especially when matter comes to the breach of a contract, because almost all the same contract law would be there in Tanzania as well as in Kenya. At that instance, to give the justice to the parties, sometimes we will take the advantage of the Kenya law, because Kenya law will help the other party more benefit instead of the Tanzania law. So we replace it with our country law with a foreign law. Why? The court will feel it. The parties which comes to the court should be not go with the empty hands. That is the intention of the private international law. If you happen to see the importance of the private international law, especially read the why is private international law important? Yes, anyone? Not the same person. Macmillan Lema, could you unmute and read?
Okay, Prof. Why is private international law important?
Yes.
Private international law aims to allow streamlined civil judicial cooperation across national borders. It seeks to avoid the need for multiple sets of court proceedings relating to the same dispute, particularly where there is a risk that these could result in conflicting judgments. All of the parties therefore save time and money by having their dispute resolved in a consistent and efficient manner, and this in turn improves access to cross-border justice for ordinary citizens.
That is the importance of it, the private international law. So private international law, the main aim is to allow the streamlined civil judicial cooperation. It will always see that the justice should be given to the parties, those who comes to the court. So across the national borders, because why do you say across the national borders? There should be two countries will be involved over there. One subject from the one country, another subject from the another country. So it seeks to avoid the need of the multiple sets of the court proceedings. So it wants to avoid the many multiple cases over there when the facts and the law is the same. At that instance, why we should not use the foreign law which give the benefit to the parties. So that is the reason we will replace the Tanzania law and we will give the importance to the foreign law and we will decide the case. Because if it does so, there is a justice the party will be given over there. Particularly where there is a risk that these could result in a conflicting judgments. Then the question comes over there. If any conflicting judgment arises over there, when you replace the Tanzanian law and using the Kenyan law, at that instance, it cannot be allowed. And the court will not allow it if there is a contradiction with the local law. So all of these parties therefore save time and money and having their dispute resolved. So they want to save the money and time and the dispute should be resolved in a consistent and efficient manner. So that is the aim of the private international law, and this is turn improves across the cross-border justice for the ordinary citizen. A citizen should not be suffered over there who comes to the court in the dispute of the private international law. So that is the main aim of the private international law, where the parties should not go with the empty hands, and the parties should be given a justice. Not only the justice should be given over there, it seems to be given. that it is a equity principle would be there. So that is the actually the thing where you want to make it out. So the foreign law could be used in place of the original law, means local law. So now let us see that there are a number of the issues that can arise before the during an inquiry in whether foreign law should be applied to the particular question or not. So whenever you apply the foreign law, there comes a number of the questions. Suppose the foreign law is contradictory with the local law of the land. That is, for instance, you take can the Kenyan law would be applied over there, whether it is in a contravention with the law of the Tanzania or not. If it is contravention with the law of the Tanzania, or it is contravention with the constitution of the Tanzania, then that law would not be applied over there. So foreign law could not be applied over there at that instance. So these issues include whether foreign law should be treated as a question of fact or law. So how could we take the foreign law? Can we take it as facts or law? So when you take both the facts and the law, at that instance we could use it and we can replace the Tanzanian law, provided it should not be contradictory with the local laws. That is the Tanzanian law. What are the roles of the judges and parties, and in some cases jury? Of course, jury system is no more now, are in ascertaining the context of the foreign law. So whether the foreign law could be used over there or not, so it is a discretion of the court to see that. And moreover, if you could use the foreign law, the justice will be given, and not only the justice will be given, and the parties will be satisfied with that one, and the parties will not go with the empty hands and with a sorrow face. So in a case of the jury, are ascertaining the context of the foreign law, when so ascertain whether foreign law is automatically then applicable, may be excluded from the application of any ground, and the extent of which an appellate court is there. So the court will decide it, whether to apply the local law, the law of the forum, or it can be replaced by the foreign law. If it is replaced by the foreign law and there is a good justice to the parties are concerned, at that instance, it is the discretion of the judges to use the foreign law in place of the local law. For instance, you take the Kenyan law could be used over there instead of the Tanzanian law, because if you could use the Tanzanian law, there is a less justice and there is a less benefit to the parties at that instance. If the benefit is more there in the Kenyan law, at that time, Kenyan law could be used over there. And now the Kenyan law is a foreign law to the law of the land. Is it or not? Is it or not? Are you following me? Are you with me?
Please repeat those network problems.
Yes. When the local law is Tanzanian law, and that to give the justice to the party, we will replace the local law, that is the Tanzanian law, with the Kenyan law. At the time, what is the Kenyan law? It is a foreign law. Then the foreign law will be replaced the local law. Why? It is the discretion of the court to see the justice to the party more if he could use the Kenyan law instead of the Tanzanian law. Because at the time of using the Kenyan law, it is not contradictory with the local laws of the Tanzania. So which is the foreign law over here?
Kenya law.
I appreciate. So the issue and the related matter or the subject matter of this chapter. So this is actually the foreign law, what is there. It is a small question. Naturally, it will be asked in the short questions, but not the long question. What is foreign law? I told you already. Read. What is the foreign law? Not the same person. Other people should have to read. Haraka. Click.
Okay, what is foreign law? Although foreign law
Yes, some matatizo is there. Some problem has come over there.
Foreign law is the law of an individual foreign country, or in some instances of an identifiable group of foreign countries like Kenyan law or Indian law or Botswanan law, etc.
So actually what is foreign law means A foreign law being expressly defined by in any statute, it implies that decided case it refers to the law of other states. Law of
The other state.
Other
other
states.
states.
Other
Suppose
states.
we are in Tanzania and we are reading the conflict of laws or the private international law here, then the other state means other than the Tanzanian law. Is it clear?
Yes.
Very good, very good. What does foreign law refers to? Just you read it. Foreign law is the law for an individual foreign country. Yes, definitely. It is a sovereign country. In some instances of the identifiable group of the foreign countries, like the Kenyan law, Indian law, Botswana law, etc., as I told you already. So they are set with the foreign laws. So now let us see how customary law and Islamic law are considered as a source of law in Tanzania. Because there is a Jala is there. I don't know how many people know. What is Jala? Yes?
The adjudication and application of laws act.
I appreciate. So here, customary law and Islamic law are established under the Section 9 of the Judicature and Application of Laws Act of the Chapter 358. What do you say Chapter 358 in other words? Yes?
Cap 358.
I appreciate. See capital letter AP, full stop, 358. And CAP is, it is abbreviation not. It is a shortening form. It is a shortening form because it is the third type of the abbreviation. For instance, I will give you that importance to that. Yeah, you can see over here because the reference has come. So there are 4 different types of the abbreviations in English. These are all abbreviations like initialism, like FDI, Federal Bureau of Investigation, FBI, and CBI, the Central Bureau of Investigation. See, here we are using the CBI, a different letters. That's why we can say initialism, we can say. But acronym, when you say ICRISAT, NATO, SATO, OPAC, these are all, we are using not the independent words, we are using as a sentence. So at that instance, you will say, yes? Anyone? NATO, SATO, OPEC, ICRISAT. Anyone?
Acronym.
It is said to be the acronym because we are not using the letters, we are using as a word all the letters. So we can say it's an acronym. And the shortening I told you now, February, if you write FEB like a CAP, that is a shortening, that is also an abbreviation. And contraction, I shall. So how many types of the abbreviations that you could now understood?
There are 4.
What are they?
There are 4, Prof.
Initialism, acronym, shortening, contradiction.
Did you know really tell me by keeping your hand on your heart this distinction? Give me the answer.
Could you repeat the question? Could you repeat the question, Prof?
Did you know that there are 4 types of the abbreviations are there? Before I could give the explanation to you. That is my asking.
No.
Keeping your hand on your heart. The answer is only Professor Hussain students know this one. No other than the Professor Hussain students know, because the reference has come. That's why I explained over here. Now let us come to our point. What is the proof of foreign law? What is the proof? If you are using the other than the local law, then we can say it is said to be the foreign law. A person who relies on the foreign law must provide it with evidence Although it is a question of fact or question of law, it is not determined by the jury. The determination of the foreign law is for the court. It is the court will decide whether the foreign law could be replaced or the local law should be used. The proof of foreign law must be provided by an expert witnesses whose competence is the question of law of the judges. It is the judge's discretion to see whether the foreign law could be used or not to be used. It is the discretion of the judge to accept for the foreign law to do the justice to the party. See, to do the justice of the party, sometimes we will replace the local law and we use the foreign law. But it is in a contravention with the existing law of Tanzania. But the condition is, it is not in contravention. It is it is not in contravention. It is not in contravention with the existing law of the Tanzania, and the judge may disregard the foreign law if it is contravention is there. Is it clear?
Yes.
Yes.
I appreciate. So now you tell me, you read what is the difference between the foreign law and the international law? Anyone? Not the same person, other person should have to read. I want to see the change of the tone.
Foreign law involves the domestic laws of a foreign jurisdiction. International law has to do with the laws that regulate conduct between sovereign nations.
Yes, international law, it deals with the sovereign nations, especially the public international law is concerned, and the foreign law, it is nothing but the domestic law of the other country. Is it clear?
Yes.
Then the foreign law is the national law of the country, other than our own country, because the country of other countries said to be the foreign law. The foreign law of the particular nation state defines the relationship with the borders. So naturally, when the private international law, there are 3 points are there. I don't know whether you could know it or not. What are the 3 main points where we will come across in the private international law? Yes. If you have an idea, you give me the answer. If you don't have an idea, you just say pass on. Quick. If you know it, you tell me. If you don't know it, you say pass on. There are 3 main ingredients would be there in the conflict of laws, that is the private international law. What are the 3 main ingredients? Don't waste the time, please. Say pass on. I will give the answer.
Pass on.
Pass, sir.
Why you are taking that much time? Do you want to search in the smartphone to know it? Don't do such a thing. You cannot ride on the 2 horses. See, number 1, jurisdiction. Which country law, I mean, which place it can be filed over there. Like we will say that forum convenience, forum non-convenience. Have you heard this connecting factor? Say yes or no.
Yes, sir.
Yes, forum convenience. Naturally, the court will give the discretion to the party to file the case, provided it will be feasible. The forum convenience is concerned. Forum inconvenience, yes, it cannot be done because it is very difficult to prove it. So, number 1, jurisdiction. Number 2, choice of law, lex causae, cause of action. What means, which country law could be used over there? Lex fori. What is meant by lex fori? Yes. What is meant by lex fori? If you know it, you tell me. If you don't know it, you say pass on. I will give you the answer. Don't waste the time.
Pass on.
Lex fori is nothing but where the case is filed, the law of the forum. That is a lex fori. Now, the foreign law of a particular nation of the state defines relation with its borders. So, other than the local law, lex fori, then the other country law is said to be the foreign law. So that is only the answer for that one. So foreign law, oh sorry, I was dealing with the three ingredients. So number one, jurisdiction. Number two, law of the choice of the law. That is the characterization also we can say. I don't know whether you know the characterization or not. Do you have an idea what is the characterization?
No.
Yes, characterization is nothing but to choose a particular case law. For instance, whether it is a conflict or it is a private international law dispute either in the tort or in the contract or in the matrimonial matters or in the divorce or in the adoption or in the transfer of property. So categorization of the thing is said to be the characterization. And where it belongs, whether the contract dispute, whether it is a tort dispute, whether it is a matrimonial marriage dispute, whether it is a divorce dispute, whether it is the adoption dispute, whether it is a property disputes. So such a categorization is said to be the characterization. Is it clear?
Yes.
Yes.
Yes. The foreign law of the another country. Just I already told you. One nation domestic law is another nation's foreign law. One nation's domestic law is another nation's foreign law. Definitely. Because the local law is Tanzania, then other country law is said to be the foreign law. And speaking from the point of the Tanzania, the law of China, France, Nigeria are all foreign laws. So why is foreign law is important? The answer is foreign law is used to learn from the manner in which other judiciary have approached the similar constitutional problems, illustrating the distinctive functions of the Tanzania system. So, provided the empirical information about the consequence, the interpretive choice of the foreign law system, it means other than the Tanzania legal system or Tanzania law. So, foreign law comes into the picture at that instance when the court feels that it is a proper justice will be given to the parties. At that instance, Lex Fori will be replaced and Lex Loci will be applied. So I am using the connecting factor. Lex Fori will be replaced. That means the law of the land where the case is filed, that for instance, if the case is filed in Tanzania, the Tanzanian law will be replaced by Lex Loci. Means the location of the another country. That is called Lex Loci. Because there is a justice to the party will be given, and justice will be given, it seems to be given. That is a theory of equity principle. So now I use the two terminology. What are the two terminology? Yes?
Lex Fori and Lex Loci.
I appreciate. Lex Fori means law of the forum, means where the case is filed. Lex Loci means the law which is in other country that is said to be the foreign law. And who does everything? It is a court. It is a court discretion. So what is foreign law jurisdiction? Foreign law jurisdiction means any jurisdiction outside the Tanzania, including without the limitation of the country, states, province, and the localities. So other than the Tanzania law is said to be the foreign law. That is the jurisdiction. And jurisdiction depends upon the, for instance, if you say the Kenyan law, the jurisdiction is the entire Kenyan boundary. Is it or not? Is it or not? Say yes.
It is.
Very good. So will Tanzania enforce a foreign court's decision? Read and put it there, the answer. Yes.
Will Tanzania enforce a foreign court's decision? Tanzania does not have a uniform law for recognition and enforcement of foreign judgments, except two acts. Tanzania courts will recognize and enforce foreign judgments based on principles of comity and understanding
Yes, there is a break of voice. I will read it. Under the state statutory provisions, where laws vary in different state and different courts. Now the question comes over there. Can the Tanzania will use the judgments of the other country or not? Of course, there are limitations are there where we can say recognition and enforcement of the foreign judgment, and where the true Tanzanian acts are there. And if it is followed over, then definitely it can be recognized and enforced of the foreign judgment in Tanzania. But in Tanzania, courts will recognize and enforce the foreign judgment based on the principle of comity. Why the Tanzania court will recognize and enforce the foreign judgment? Because the principle of comity. Can anybody tell me what is the principle of comity? Yes? If you know it, you please tell me. If you don't know it, you say pass on.
As how I understand, it's just the respect of territorial sovereignty.
Repeat.
As how I know, it's the respect of the territorial sovereignty.
I appreciate. You are right. See, we regard the Kenyan law, and the Kenya will regard the Tanzanian law. So reciprocity would be there, and that is called a principle of comity. So give respect and take respect. For instance, if you go to the, I don't know whether it is there, what is famous in the Bukoba? What is the famous in the Bukoba where the people will be offered? Indizi.
Banana.
Suppose from you are going from Moshi to Bukoba. At that instance, if they offer you the good type of the banana and you deliciously enjoy it, but when from Bukoba, that if you go to the Moshi, what is famous in the Moshi?
Also banana.
Yes, you also give a good variety of the banana, because you treated when you go over there in Bukoba the same way the treatment should be there when you come to the Moshi. So it is like your reverence. A reverence will be given to our country law, and the same way the other country or the country which also give the reverence to the foreign law. So giving respect to the foreign law of each other, because for Kenya, Tanzania is a foreign law. For Tanzania, Kenya is a foreign law. Am I right? Say yes.
Prof, can you repeat? I haven't heard it because of the network.
Yes, could you repeat, Prof?
We are giving the reference to the Tanzanian law, because who? Kenyan law. Kenya is giving the reverence and respect to the Tanzanian law. In the same reciprocity manner, Tanzania should have to give the respect to the Kenyan law. That is reciprocity. Reciprocity is set to be the principle of comity. Giving reverence, giving respect. Is it clear?
Yes, Prof.
Yes, under the state statutory provisions, where the laws in very state, different state or different countries. Of course, different states is having the different laws and different courts also. For instance, what is the apex code in Kenya? Yes. What is the apex code in Kenya? If you know it, you tell me.
Pass.
I'm sure that the apex court is Supreme Court. To my knowledge, subject to the correction. But when you say what is the apex court in India, then I can say it is the Supreme Court of India. Then what is the apex court in Tanzania?
Court of
Court of
Appeal.
Appeal. you.
Court of Appeal. So naturally, the apex court decision will be taken to give the respect to the decisions, and there we can use the recognition and enforcement of the foreign judgment, because it is the apex court which is given the judgment in Tanzania Court of Appeal, and it is the apex court which is given the judgment in the India is the Supreme Court. So it depends upon the court of the case. We can directly take the Indian judgment to apply in the Tanzanian disputes where the private international law is there, where the two courts, where the two countries are involved, Tanzania and India. Okay, we do have a separate chapter. At the time you can see the recognition and enforcement of the foreign judgment. And I wrote an article. It is published in the LST. That is a law. What is LST? I forgot. And you have done through the training.
The Law School of Tanzania.
Yes, there is a Law School of Tanzania.
Law School of Tanzania?
Yes, yes. I published it in 2016. Of course, I will show you later. Recognition and enforcement of the foreign judgment between the Kenya and Tanzania. That is the title of my article. And there I discussed the cases also. And I discussed some of the acts also there. And really, even I can send you to your WhatsApp so that you could read it when you come to the class. We can have a participatory class. When a foreign judgment could be used, when a foreign judgment could not be used in the local laws. I mean, lex pori. So now let's see, the private international law is a part of the international law. Yes, naturally the public international law versus private international law, that you know it. Public international law is govern the relationship between the nations, and the private international law deals with the private relationship across the national borders. Because it's an individual to the state and an individual to the another individual of the national borders, means two different states. So public international law and private international law difference. As I told you already, that public international law is a body of the rules applied in the conflict of sovereign states, and the private international law is a procedural rule or domestic law between one country to another country, where the dispute arises when the two countries are sovereign states and having their own legal system. Is it clear?
Yes.
Yes.
Now, what are the types of international law? Of course, here, do you have an idea at least what are the types? Yes? Do you have an idea what are the types of the international law? Yes, tell me.
I am aware of two.
Yes, Prof.
You know only the.
I am aware of two.
Yes, so you know only the public international and private international law. But there is a supranational law also there. So international law is divided into the public international law, private international law, and the supranational law. Then we can see what is the supranational law. It is nothing but a forum. The forum of international law, where in the sovereign nations submit to the judicial decision of a common tribunal. So the forum, which is nothing but given the power to the tribunal. So such is called the supranational. For instance, you take, if a public international law, sovereign states negotiate with each other. Yes. But when the supranational involves tribunals outside and above the authority of any state. So where the tribunal will come into the picture, that is case. For instance, the major supranational tribunals are the European Union Court, that is the European Court of Justice. It is one of the tribunal, is a court. The United Nations Security Council, it is also a tribunal on the court. And the UN organizations like the International Court of Justice, yes, it is a tribunal and the court where it can be dealt, and that is called supranational law. Just for the explanation that I want to make it out. So Supranational law is nothing but it is the tribunals law and tribunals connected with it and which will decide it. Then we can say supranational law. Just for our academic purpose that you should keep in mind. So such a thing, that is even the International Court of Justice is a tribunal where it can deal the cases. Yes, can you tell me what type of the cases the International Court of Justice will deal? Yes.
Crimes against humanity?
Yes, it can. Yes, it is also there. And if any human rights violations would be there from one state by another state, yes, it can be dealt in the International Court of Justice. Where is the headquarters of the International Court of Justice, please? Yes. If you know it, you tell me. If you don't need it, you say pass on. Without wasting the time, I will come to your rescue. And I give you the answer. Click. I already told you. And I explained you. Don't type in the smartphone to see where is the International Court of Justice. Click. Say pass on.
That's
Yes.
one.
Pass on.
International Court of Justice is in The Hague and which is in Netherlands. It is only one organ from out of the 6 organs which is other than the New York. The other all 5 organs there of the UNO in the New York itself. So European Union itself is considered as a supranational political entity. So it is also the supranational law. So what is an example of the international law? It's nothing but the rule of international law are found in the treaties, conventions, declarations, protocols, agreements, customs, and other sources. For example, Kyoto Protocol is an international agreement on a climate change. I don't know whether you know it, Rio de Janeiro. Rio Janeiro or Rio, yeah. The Rio Protocol is there, especially it deals with the environmental and the depletion of the ozone layer, if it is not mistaken. So that will be the treaties will be taken place in the Rio de Janeiro. So what are the 3 main issues commonly dealt with the private international law? Just I already told you. What are they? Read. Read.
They bring a common law perspective to contemporary problems concerning the key issues in private international law: jurisdiction, choice of law, and recognition and enforcement of foreign judgments.
So these are actually the 3 elements should be there in the private international law. Which court is having the jurisdiction to entertain the case? Number 1. Number 2, what is the applicable law? That is a characterization. Yes, what law should be applied? Whether the law of the land, that is Lex Fori, or the law of the other country, the foreign law, Lex Loci. Then the question comes, can you take the judgment of the other country? As I told you, the doctrine of comity, when you apply it, if you consider the Tanzanian decision by the Kenyan court, at that instance, Kenya also will consider the Tanzanian decisions because of doctrine of comity, that is a reverence. So what is an example for in a case of the private international law? So the private international law consists of the principles and rules for dealing with the legal disputes that have a foreign element, for example, cross-border divorce case, or the transitional or transnational commercial dispute case. Any breach of contract is concerned between the 2 countries, that is the private international law dispute. So How does the private international law work? Yes, private international law governing the dispute between the citizens, humans or corporate of a different countries and citizens or human corporate against a foreign country. And disputes in international private law are often solved via, generally it will be the negotiations, arbitrations and litigation or a combination of all these. Yes, that is a shortest and easy way to resolve the dispute. The best way of giving the judgment is, yes, anyone? The best way of dealing the dispute is, yes,
Negotiation. Negotiation.
yes, that is the best way. And the negotiation or arbitration or litigation or reconciliation and all these things comes settlement. It all comes under
Settlement.
the best way of resolving the conflict is settlement, because the loser also lose, the winner also lose. The only difference is the loser weeps in the court and the winner weeps in the house. I don't know whether you got my point or not. Tell me.
No. No, I've not got your point.
Okay, I will explain you. See, when you go to the court, either a civil dispute or criminal dispute or the private international dispute, doesn't matter. It takes its own time and sometimes it is resolved. For instance, civil cases, it will take the years together, and even a person who filed a case also loses money and time, and person who is defending the case also losing the time and money. At the last, somebody won, but the outcome is a person who won, he goes to the home and weeps because he lost many money and time and youth and many other things. Instead of he won the case, because of time consuming and winning the case, and there is no meaning of it. Because as the equity principle says, justice to be done and it seems to be done. If civil litigation takes 40 years to resolve the land dispute, what is the use of it, you tell me? That is number one.